Imagine this. A legal case, years in the making, just poof, vanishes. Because of a tiny procedural detail. Sounds almost impossible, right? Like something out of a legal drama designed to make you tear your hair out. But in the complex world of law, sometimes the smallest misstep can make a whole dispute disappear. Welcome to the deep dive. We take dense information articles, research your notes, and pull out the key insights. Those aha moments you need to be properly informed, but without the usual information overload. Today, we're diving deep into a really interesting civil appeal from the Supreme Court of India. Judgment dated July 18th, 2025. It's Suresh Chandra, deceased, through LRs versus Parsaram Ors. And it tackles this critical question: what happens to an entire appeal if one person involved dies and their legal reps aren't brought in on time? It's a fantastic example of how these procedural technicalities can totally change the outcome of a long running property fight. Our mission here is to unpack the core legal ideas and the, well, surprising ways they shape how justice actually works. Okay, let's unpack this. Our story starts way back in 1983. Civil suit number 13. What was this original fight all about?
Right. So at its heart, this was a fight over a house. Pretty classic stuff, really. The plaintiff, Parsaram, he claimed his ancestor, Singh, was the sole owner. Said the defendants, Suresh Chandra and Rambabu, were just tenants.
Tenants. So what was the basis for that claim?
Well, Parsaram pointed to municipal records from 1938 showing Singh as owner, and he claimed the tenancy went back to 1937, with rent supposedly paid to his family. He also alleged the defendants had encroached on the ground floor, even sublet parts without permission, and that's why he said the tenancy was terminated.
Okay, so that's the plaintiff's side. How did Suresh Chandra and Rambabu, the defendants, push back?
They filed a joint written statement, and that word joint becomes really important later on. They absolutely denied being tenants, completely rejected it. Instead, they claimed they were the absolute owners through their ancestor, Gokul Prasad.
A different ancestor.
Exactly. They said Gopal Prasad got the property way back in 1947 in a family partition with his brothers, which included Singh.
So, two completely different stories about who owned the house. How did it play out in the lower courts?
It was a bit of a roller coaster, actually. The trial court. Surprisingly, it dismissed the plaintiff's suit, said Parsaram couldn't prove exclusive ownership or the tenancy.
Okay, so advantage defendants initially.
Right. But then came the first appellate court, and this is where the tide really turned. That court decreed the plaintiff's suit, ruled that yes, the plaintiff was the owner and the defendants were tenants. A total reversal.
Wow, okay, so facing that loss, what did Suresh Chandra and Rambabu's side do? Or their LRs, I guess.
Precisely. The legal representatives, the LRs, of both Suresh Chandra and Rambabu, they filed a second appeal in the High Court to challenge that appellate ruling against them.
Right, and this is where things get really interesting, isn't it? Where a procedural point takes center stage. What happened with Rambabu during this second appeal?
This is the crux, yeah. Rambabu, he was appellate number 2 in that High Court appeal. He passed away on August 19th, 2015. Now, the court was told about his death that happened on April 4th, 2016.
Okay, so the court knew.
The court knew. But crucially, his legal representatives, his LRs, they weren't brought onto the record within the time limit the law sets out.
The deadline was missed. What did the High Court do about that?
Well, much later, in an order dated February 24th, 2022, the High Court declared the appeal had abated.
Abated, meaning?
Meaning it essentially died, it came to an end because of this failure to substitute the LRs.
And what about trying to fix it? Did they try to get the delay excuse?
They did. Applications to condone the delay, excuse it, and to substitute Rambabu's LRs were filed by both sets of LRs, Rambabu's and Suresh Chandra's. But here's the thing. They only filed them in 2022.
Years later, and after the court had already said it abated.
Exactly. And the High Court wasn't having it. On August 4, 2022, it rejected both applications, said there was no sufficient cause shown for such a massive delay. They pointed out, look, he died in 2015, the court was told in 2016. Why wait until 2022? And they also noted the appellants were close relatives. It strained belief, the court thought, that they wouldn't have known about the death much, much earlier.
So the High Court basically said, too little, too late. Rambabu's part of the appeal was definitively gone. What did the remaining appellants, Suresh Chandra's LRs, do then?
They went up to the Supreme Court. They appealed both the abatement order itself and the rejection of their applications to excuse the delay. And this put two really key questions before the Supreme Court.
Okay, let's tackle those. First question, did the High Court mess up by refusing to excuse the delay and allow the substitution?
On that point, the Supreme Court found no fault with the High Court's reasoning. They looked at the timeline, too. Death in August 2015. Court informed April 2016. applications only in 2022. The Supreme Court agreed, given they were close relatives, it just wasn't believable they were unaware for all that time. So the finding of no sufficient cause for the delay, upheld. The High Court got that right, according to the Supreme Court.
Okay, so the delay wasn't excused. That means the second question becomes even more critical. Even if Rambabu's part was correctly abated, did that mean the entire appeal had to abate? Or could Suresh Chandra's LRs continue the fight alone?
Exactly. And this is where we get into some fundamental principles of civil procedure law. It's about this concept of abatement in appeals. It's mainly governed by Order XXII of the Civil Procedure Code, the CPC.
Order 22.
Okay. Right. And Rule 11 basically says the rules for suits apply to appeals. Now, Rules 3 and 4 generally suggest that if LRs aren't substituted, the case abates as far as the deceased party is concerned. So only partially.
Which sounds logical. Why should the others be penalized?
Well, that's where the law has developed a crucial exception. Sometimes the abatement for just one party can affect the entire case. It can be fatal to the whole appeal.
How does that work? Why would it affect everyone?
It hinges on whether the original court decree, the one being appealed, is considered joint and indivisible, or joint and inseverable. If the decree fundamentally binds the parties together in a way that can't be separated, then knocking one out through abatement can bring the whole appeal down.
Joint and indivisible. Why is that the standard? What's the risk otherwise?
The big risk is ending up with inconsistent or contradictory decrees. Imagine two court orders about the same property that completely contradict each other. How could you possibly enforce both? The Supreme Court explained this really well in a big 5-judge case, Sardar Amarjit Singh Kalra. They said decrees are contradictory if enforcing one would make enforcing the other impossible, if they're mutually self-destructive.
Mutually self-destructive. That's a strong phrase.
It is. Basically, if you put the two potential outcomes side by side, one is, quote, in the teeth of the other. They just can't coexist legally. An older case, State of Punjab versus Nathu from 1962, laid out some tests too. Like, would the success of the appeal for the survivor conflict with the now final decision against the deceased? Could the survivor have even sued alone in the first place? Would a decree just against the survivor even be effective?
So the courts are really focused on ensuring the final outcome is logically consistent and actually workable.
Exactly. It's about maintaining the integrity and enforceability of judgments. The Supreme Court pointed to several examples to illustrate this. Like in that Nathu case itself, it involved a joint compensation award for land. The court said you can't have different values for the same piece of land just because one owner's appeal abated. The claim was joint, so the abatement was total.
Even if they had separate shares on paper.
Yes. The court specifically rejected that argument in Nathu, said the claim for compensation was joint, regardless of individual shares listed elsewhere. Or take a partition suit case, Venigalla Koteswaramma. If an agreement was upheld for some, but not for a deceased defendant whose appeal abated, that would create, quote, inconsistencies galore. It pops up in will validity cases, co-ownership declarations, even cases with joint guarantors. If letting the appeal proceed for some would create a direct contradiction with the result that's become final for the deceased party, the whole appeal often has to abate.
Okay, that makes the logic clearer. It's about preventing impossible legal situations. But then, what about Order XLI, Rule 4? Doesn't that rule allow one appellant to sometimes win for everyone if the issue is common? Why didn't that help Suresh Chandra's LRs here?
Ah, yes, Order 41, Rule 4. That's another crucial piece of the puzzle. And the timing of when these rules apply is key. Order XLI Rule 4 operates when an appeal is first filed. It gives the court the power, if one person appeals on a ground common to others who haven't appealed, to potentially reverse or change the decree for all of them. It's a power given to the court at the start.
Okay, so it's about initiating the appeal.
Right. Whereas Order XAD about abatement kicks in during the appeal process after it's already been filed. If someone dies while the appeal is pending, Order XCT says you must substitute their LRs. If you don't, abatement happens.
So they operate at different stages. How did the Supreme Court say they interact?
They relied heavily on a 1963 case, Brahmeshwar Prasad. In that case, all the plaintiffs had jointly filed the appeal. Then one died, LRs weren't substituted. The Supreme Court held that Order XLI Rule 4 could not say the appeal for the survivors.
Why not? The grounds were common, presumably.
Because the appeal was filed jointly by everyone from the start. It wasn't a case of one person appealing on behalf of others who were maybe just respondents. The court essentially said you can't use Rule 4 retroactively to rescue a jointly filed appeal where one of the original active co-appellants has dropped out due to abatement.
So it really matters how you set up the appeal, who is actively appealing versus who is just named.
Precisely. It's a critical distinction. This was confirmed again more recently in Gola Vijayalakshmi. But importantly, the court also clarified in Mahabir Prasad back in 1971 that if only one person appeals and the others who share the common ground are just brought in as pro forma respondents,
Pro formam.
meaning they're included for completeness, maybe because they were a party below, but they aren't actively driving the appeal. They're sort of passive participants on the respondent side. In that situation, if one of those pro forma respondents dies and isn't substituted, Order XXII Rule 4 could still allow the sole active appellant to potentially win for everyone, because the active appellant initiated it alone.
So active co-appellant versus passive pro forma respondent makes all the difference for Rule 4.
It does. And in our case, Suresh Chandra and Rambabu were co-appellants. They filed the second appeal together jointly.
Which meant Rule 4 was off the table for Suresh Chandra's LRs once Rambabu's part abated?
Exactly. And that's why the cases the appellants tried to rely on, like Delhi Development Authority, didn't fit. That case involved suing on behalf of others. Not applicable here. And another case they cited, Sukharam, the Supreme Court actually called it per incuriam.
Per incuriam, meaning
Basically decided wrongly because it ignored binding previous decisions. Specifically, the court said Sukharam failed to grapple with that core issue of avoiding contradictory decrees.
Okay, so bringing it all back home to this case, Suresh Chandra and Rambabu, what was the final verdict from the Supreme Court, tying all these threads together?
Right. So remember, Suresh Chandra and Rambabu had a common defense, joint ownership through their father Gokul Prasad. They stood or fell together on that claim. The first appellate court rejected that claim. It said Parsaram was the owner and they were tenants. That was the decree being appealed.
Okay.
When Rambabu's part of the appeal abated because his LRs weren't substituted, that decree saying Parsaram is owner, Rambabu was tenant, became final and binding as against Rambabu. It could no longer be challenged for him.
Set in stone for Rambabu.
Exactly.
Yeah.
Now imagine if the Supreme Court allowed the appeal to continue just for Suresh Chandra's LRs. And imagine they succeeded. They managed to prove their joint ownership claim. What would you have? You'd have one final unchallengeable decree saying Rambabu, and by extension his share based on the joint claim, was a tenant under Parsaram. And right next to it you'd have a new decree saying Suresh Chandra, based on the same joint claim to the same father, was an owner.
Contradictory decrees about the same property, based on the same core claim.
Yeah, precisely. Mutually self-destructive, incapable of logical enforcement together. One says tenancy, one says ownership, stemming from the same alleged source. That's the inconsistency the entire legal framework here is designed to prevent.
So the court had no choice, really, under these principles.
Based on this long line of precedent, yes. The conclusion was clear. First, they upheld the High Court. No good reason given for the delay in substituting Rambabu's LRs. Second, and crucially, because of the potential for these inconsistent decrees arising from a joint and indivisible claim, the entire second appeal had abated, not just Rambabu's part. And third, because Suresh Chandra and Rambabu had jointly filed the appeal as co-appellants, Order XXII Rule 4 couldn't be used to save it for the survivor.
Wow, it really drives home how interconnected these procedural rules are and how high the stakes can be.
Absolutely. It's a powerful illustration.
So if there's one core lesson for anyone navigating the legal system, especially with complex disputes involving multiple parties, what is it that this case screams the loudest?
It really screams that procedure isn't just, bureaucratic box ticking. It's fundamental. Missing a deadline, especially for something like substituting legal representatives in a joint claim, it can completely derail the substance of your case. Regardless of how strong you think your arguments are on the merits, the system prioritizes consistency and finality, sometimes even over allowing every argument to be heard if the procedure wasn't followed correctly, especially when it risks contradictory outcomes.
This deep dive really highlights that, doesn't it? How critical legal procedure is. It shows that even when you're chasing justice, something that sounds as dry as timely substitution of legal representatives, well, it can be the deciding factor, especially with these joint and indivisible claims. The court's laser focus on preventing contradictory decrees, it just underlines the careful logic that governs judgments. It's all about ensuring legal outcomes are consistent, enforceable, and make sense in the real world. This case really makes you wonder, doesn't it? How many other claims that seem solid on the surface, might actually unravel. Not because the arguments are weak, but because the precise, maybe even finicky execution of these procedural rules. What does that tell us about the kind of hidden power of legal technicalities, how they shape outcomes, and just how vital it is to be truly well informed about every single layer of the law, not just the big picture arguments. Makes you think.